Hello, I am an immigration attorney, Natalia Porsche, and my office is based in Biloxi, Mississippi. And in this video, I will tell you what you can do in order to protect yourself from being deported if you are non-citizen in the United States and who is here without permission or authorization to be here. For example, your visa has expired or you entered the country illegally unauthorized. So first of all, if you are here in the United States illegally, or your visa, for example, expired, or you enter the country illegally, you can apply for some sort of relief, for example, asylum or withholding of removal, and that's when you're afraid to go back to your own country, to your country of origin. How you can do this? You can file application I-589 with USCIS. Now, if you're already in immigration removal proceedings in immigration court, you can also submit your I-589 with immigration court with jurisdiction over your case and apply for asylum or withholding of removal if you're afraid to go back to your own country, or if you think that you will be subject to torture if you return to your own home country. So that's number one. Now remember, as of now, before we will see any further changes, you can apply for a work permit 180 days after you file your application for asylum with USCIS or an immigration court that has a jurisdiction over your case. So number one, having a work permit, having a true, not expired, legit work permit, and then I'll explain you later what I mean by legit. So if you file your application with immigration court for asylum, for example, you file in 180 days application for work permit, you will receive your application for work permit, and that is good. Your work permit will be good as long as your case is pending. Now, what can you do if your case has been terminated? Now, if your case has been terminated or dismissed for any reason at all in immigration court, here arguably you already don't have a pending case in immigration court. Therefore, the work permit that has been issued based on that application I-589 that has been pending in court now is not valid. So you also will have to keep this in mind. Now, driver's license. Have an active, valid, not expired driver's license. In a lot of states, majority of them, you can apply for a driver's license because the main and major reason why when ICE, let's say, pull you over, or a local police enforcement pull you over and you're driving without driver's license, of course, you will receive a ticket, right? You will be charged with a misdemeanor, for example, in Mississippi for driving without license. So here, if you have a valid license, if you were pulled over by a police officer, you can show your valid license. Therefore, at least you will not get a ticket for driving without driver's license. When you get your driver's license, therefore you can get your insurance and you will not be violating any rules of the road. Therefore, if you don't violate, you don't speed, you don't pass the stop sign without stopping, therefore there will be no reasonable cause to pull you over and you are legally in the United States, legally meaning your application for adjudication as defense of deportation is pending right now with court, for example, right? Number three, you always can retain an experienced immigration lawyer to defend you from deportation or to proceed with your, for example, cancellation of removal defense or asylum defense. So that lawyer can watch over your case, and if you get detained for any reason at all or without any reason, and I have seen cases like that when the person had a work permit, pending asylum application, they still were detained at the construction site. So therefore, you can have your attorney ready. You can ask your employer to retain a lawyer, and a lawyer will be watching over your case. And in any event, let's say if you detained by ICE, therefore the lawyer can file for a bond and argue that you did not violate any laws, therefore you can be released on your own recognizance, meaning without posting any bond, or a minimum amount of bond that you can post, which is $1,500, for example. Now, have a money ready for bond and have your documents ready for bond. What will you need to apply for a bond? Let's say if you detained, for example, by ICE, and now you have to apply for a bond. You have to have a letter of sponsorship. Majority of immigration judges will require that. You have to have a bond sheet work, okay? So you'll have to fill it out. You'll have to tell the judge, show that you're eligible for bond. Here, for example, in Fifth Circuit jurisdiction, client has a burden to show that he or her is eligible for a bond. It's not the DHS duty to establish that you are not eligible for a bond as a non-citizen. It is your burden to establish that you are eligible. In some other jurisdiction, I believe it's Ninth Circuit, or if I'm mistaken, forgive me, other jurisdiction, for example, the DHS, Department of Homeland Security, the immigration, the government has a burden to show that you are not a danger to the community or a flight risk. Here in the Fifth Circuit, you have a burden to show that you are not a danger to the community or a flight risk. Now, if the judge determines that you are not a danger to the community, and that's when you don't have any criminal charges pending, your criminal charges have been resolved in your favor, therefore, if you don't have a substantial ties to the United States, this amount could be mitigated by the amount of a bond that you can ask to be granted to you by an immigration judge. Now, if the judge determines that you're a danger to the community, here it's somehow it's more difficult to win a bond case, more difficult. So what if you lose your bond case? If you lose your bond case, remember, you always can apply for a voluntary departure, right? So I saw all kind of stuff happening. I saw a person, a non-citizen, who had a pending DUI case, which was not resolved, which was still pending with county. I saw this client getting a voluntary departure. I saw clients not getting voluntary departure. So the main thing that the judges look at in granting voluntary departure, and it is whether you have a passport, whether you can afford your tickets back, to buy your tickets back to your own country. So if you can satisfy these two, the judges likely will exercise positive discretion. Although, for example, if you have a DUI pending file, I saw cases like that happening here in the Fifth Circuit. Now, this is all you need to know, really, about how to protect yourself during this hard time of deportation. A lot of cases, they are in between. We get majority of cases, for example, when the person has been here in the United States, non-citizen, for years and years and years without any criminal record, but the problem is he or she cannot apply for cancellation of removal because they don't have a person and a citizen or a legal permanent resident they can use to establish the hardship right, to that person. So therefore, they're not eligible for cancellation of removal. So those cases are very hard. And so what can you do in this kind of cases? Well, you have to think about, other ways, right? You have to think about consult with an immigration attorney, and you have to figure out what is better for you to do, to go back home and start from the beginning. And remember, if you have a valid order of deportation on your name and you decide to return home and you actually go back, so that will be how you execute that order of deportation, right? So now you will have a bar for 10 years from re-entering the United States. Again, always consult with an immigration attorney, and I hope this video was helpful to you. Thank you so much for watching, and if you like my videos, put thumbs up, make a comment.